where the ranking member started his line of questions with some precedent. What I'm seeing here is two overarching issues. Number one is, despite what folks may claim, the law is actually unsettled on executive privilege. We can go through some of the case law briefly, but also the other issue is this committee outside the scope of Congress? Meaning, is it more of a criminal investigation, which is clearly not a legislative function, or is it engaged in a truly legislative function, which is important because the case law talks extensively about whether the subpoenas are for other purposes other than a legislative function. So when we're talking about these issues in the case law, do you see those as the two glaring issues here?
I do, outside of the specific scope of, this specific subpoena. And listen, I'm not the person to contest that this committee has a valid legislative function. I think they do. I do think the rhetoric and we've had members of the committee reading criminal code on national TV about what is going on, how this works, and then throwing that throwaway line at the end about towards a particular legislative purpose. But so at least in the rhetoric and in the actions of how they try to well, it's not enforce, penalize this is different.
But wouldn't you agree that Congress has the authority to investigate only for legislative purposes? So
yes.
Anything that,
specifically, yes.
And then to that end, when Congress issues a subpoena, it can only be for a legislative purpose. For example, okay.
Subpoenas solely for the purpose of sunlight are specifically held not to be a clear legislative purpose.
In some of the precedents that reference this are Quinn, Watkins, and McGrain. So for example, in Quinn, Congress cannot issue a subpoena for law enforcement purposes. Then you have Watkins. Congress has no authority to issue a subpoena to compel for the sake of exposure, just to expose and embarrass. And then McGrain, where it says Congress may not issue a subpoena in an attempt to, quote unquote, try somebody before a committee for any crime or wrongdoing. Given those three precedents, do you see this subpoena and the actions of this committee falling within the territory of those precedents?
I do, and I think the biggest issue is how they respond to any legitimate, real request for narrowly tailoring or moving on. And in fact, they did the opposite. They expanded it, and then when there was communication back, it was just like, we have authority. That's literally the answer, is we have authority.
It's an incredibly circular argument. And again, just the FBI and the U.S. Attorney's Office are the proper bodies to do an investigation that's criminal. Again, I'll say, if it's a legislative function, I get it, that's our purview. But for the criminal investigation, what's the proper authority?
Absolutely, it's the DOJ. And by the way, the proper authority to enforce a subpoena is civil court.
When we look at Mr. Scavino's case, and there's a few things that stick out to me. Number one is he actually has a letter from the president. Remember, it's the president's privilege to assert here. And two, he was a closer advisor to the president. And to go back to a precedent we haven't talked about, which is the Nixon case, the Nixon case said that the reason you have executive privilege is because those around the president have to be able to give candid advice, much like a lawyer would give a client, without the fear of that coming to light in the future. So given those 2 points, do you have any thought on Scavino's argument in particular?
Yeah, and I think it is not settled. And this is not just about a document production, and this is not just about testimony. It has both. And I think in both cases, it falls outside of the narrow exception in Trump v. Thompson.
When we're talking about Mr. Scavino, I know there was talk about the back and forth with his lawyers, et cetera. I think you were in the room when I offered a letter from Mr. Scavino's attorneys. But by the way, has not been answered by either the committee or the White House yet. But that letter talks a lot about due process arguments. Are you familiar with all the due process issues? And if so, can you expand?
Sure. It's pretty hard to meaningfully prepare for a deposition when you can't get a meaningful answer, and the correspondence expands on the original subpoena, and the original subpoena is clear that they felt was overly broad, duplicative, and a lot of different issues. And they would go 45, 50, 100 days without getting a response, and then they get a response saying you must comply. The response from the committee would be you have 3 days to comply with this. There was no meaningful engagement that I am aware of on any of these issues. And you might not agree with these issues, but it's not a, I mean, it's a very cogent, very detailed legal argument that has been consistently made.
And you see a huge problem with the fact that the scope was constantly expanding, so it gave Scavino no opportunity to prepare.
Yes.
And what about the burden shifting too, where at one point in the committee basically said, you hand over what you think is relevant? I mean, what are your thoughts on that?
And by asking or presenting what is truly a false choice about doing this and claiming privilege with very specific documents and limiting to a privilege log in order to comply with what you're asking without ever meaningfully engaging on what you're already disputing is absolutely burden shifting to the witness and forcing them into a position that is, in often cases, would be a distinction without a difference.
Are you familiar with the case US v. Renicky? I might be mispronouncing that.
I'm not sure. I've read a lot in the last 3
Okay,
days.
so that's fair. So the U.S. Court of Appeals overturned a perjury conviction for somebody who, obviously Renicky, who was found guilty of lying to a Senate committee. But the court did that because there wasn't a quorum present in the committee. So does that jar your memory yet? Do you have thoughts on that? Because I feel like the due process violation, a lot of people just think we're talking about due process violations, but the court has held that even a quorum being busted is grounds for overturning a perjury conviction. Can you just relate that case to what's going on with Scavino?
Yeah, I mean, I just think that, I mean, listen, all of the courts have held in varying different degrees in how of this works. Your best option for any congressional enforcement conviction, civil enforcement, all of that, is that you're very narrowly tailored for a very specific purpose. And there's a real due process reason for that, because the broader in scope and the more expansive in scope, and when you deal with all of these things and then you expand it after the fact, it is very meaningful. It is very, very difficult to actually provide due process to the person who is coming in front of you, because the answer is we want everything, all of it, we don't care. I mean, and that truly, I mean, is how that works. And then how do you meaningfully prepare a client? How do you do any of these things? I mean, there's a reason courts have held the more specific and more narrowly tailored it is, the better likelihood of enforcement, and I would argue a better likelihood of conviction or prosecution.
Right. And then finally, let's say Congress holds these two individuals in contempt. It's ultimately up for the DOJ to prosecute, correct?
Yeah, I agree with Congresswoman Cheney. The first time in 40 years is Mr. Bannon, and I mean but that also includes Eric Holder, which was bipartisan, and Lois Lerner as well. I mean, and I think it's more important to recognize. I mean, the most important thing is if we continue to have people come in here and talk and go on TV and talk about compliance with the subpoena, the last way you're getting any of that information is by prosecuting them for contempt.
And then, are you aware that DOJ has a long-standing position where they actually will not? They will allow executive officials to assert privilege and not hold that in contempt, and that goes back to Ann Gorsuch with the EPA. Would you like to expand on that?
No, but I mean, I think you can. I mean, I think the minute you start pressuring with rhetoric and other issues the DOJ to start dealing with these issues in these types of ways, you run the risk of, listen, there's not a ton of respect out there for Congress right now. It doesn't matter where you go anywhere in the country. The last thing in the world we need is that to be bleeding into the Department of Justice.
Thanks, Mr. Armstrong. I appreciate it. I yield back.
Thank you.